Sorry, I have to again the same thing as recording has not been started. So, hello all, I welcome all the attendees to the seventh webinar organized by Visual Associates, a law firm providing litigation and ADR services. I welcome all the participants from USA, Malaysia, Philippines, Sri Lanka, Pakistan, Afghanistan, Bangladesh, Nepal, and Bhutan. We also have participants from almost 23 states of India with us in today's webinar. The topic for today is mediation, win for all. As we all know, the mediation is a process to resolve disputes. Resolution come with a win-win situation for both the parties. And why we add win for all, this word is a specific reason because nobody is lost when a dispute resolved by way of mediation process. It may be a different type of disputes are been there, a family dispute, commercial dispute, and dispute between nations. But the purpose to using mediation process is always is bring peace and harmony. To discuss today's topic, it is indeed privilege for us to have a very special guest, Professor Daniel Erdmann, Director and Founder, World Mediation Organization, and Professor of Mediation and Conflict Resolution, UCLA University, who is enlightening us on this today's topic. So, Daniel, first of all, I just want to know, can you tell us about the history of commercial mediation?
Well, first of all, before starting with the proper topic, I would like to give back my appreciation, and I would once again like to tell everybody who is involved in this project that I'm very grateful that I can spend my perspectives today and meet so many people at once. Thank you. So getting back to your question about commercial mediation. Well, mediation, as far as I understand, is actually a social skill that is as old as mankind and possibly does exist as long as there were social creatures living on Earth. So mediation is definitely not only the formal construct that was recently developed and that widely differs from country to country. But it is more likely the middle way of dialoguing and creating mutual understanding. And therefore, and due to the nature or its nature, it is closely connected to bargaining and creating consensus. So based on this information, you may imagine that commercial mediation might have been implemented to the field of trading and exchange at a very, very early age of human existence.
Yeah, it's really something. The other one is, are there any sanction if the parties to the dispute process in mediation or other ignorance the proposal or refuse to mediate or frustrate the mediation process? Is there any sanction is needed?
Well, mediation and the processes that are connected to it extremely differ on a global level. And in some countries, mediation is, for example, a mandatory pre-court process, while in other places, it is still not even connected to the legal framework. And in case that mediation is a binding process prior to a court case, there are several supportive reasons that we mainly all know, but that may avoid the necessity of creating sanctions. To only name a few, it is generally a much cheaper and a much faster process in handling a conflict, and it thereby brings results in a more comfortable setting than any case within a nation's jurisdiction might be able to deliver.
That definitely it will depending upon the jurisdiction and the process of different countries. Yes, exactly. So the other one is there is many question in our mind. So I'm just trying to clarify, and our participant will also will understand about the mediation and their process. So must a mediation to disclose a conflict of interest? What would be the considered of a conflict of interest? What are the consequences of failure to disclose a conflict of interest of a mediator during the mediation process?
Well, I think mediation and conflict in general is the perfect environment of conflicts of interest. First of all, we have the participants who present perspectives that seem to be incompatible to them. And we also have, on the other hand, the mediator or the team of mediators who, of course, have their personal perspective regarding the content. So I think it is the mediator's task to handle the process in a non biased way and to exclude personal conceptions. And I would definitely call the process of mediation not, or I would try to call it like an open process where exchange and dialogue takes place. I would definitely not try to sell a guaranteed solution to a conflict because mediation is a team process and none of the participants actually holds the complete control over it, but only supports it in a proportionate way.
Professor, can you tell us what is the prospect of mediation in India as on a market, on a professional manner, in respect of the disputes and different kind of disputes? What is your view on that?
Well, this is a very difficult question as it totally depends on what India and especially the government makes out of it. To me, it is actually a question that raises even more points to reflect on afterwards. So, generally, it depends on the frame that is granted by the government for the positive development and acceptance of mediation throughout its citizens. And obviously, in India, there is a huge market for mediation. But the previously setting or frame determines the future of mediation in a very meaningful way. So, as long as mediation is an alternative tool used by lawyers, this may be fine for legal advisors. But let us just imagine what happens if the government creates a new branch, an industry of pre court conflict management. So, what would happen when the League of Lawyers generates less income as pre court mediators with no legal education close conflicts or conflict cases in a huge number? So the question is, will there still be harmony between both branches, or will each of them start struggling for their proper purposes and prosperity? So I guess this question, at least for the moment, might remain open. But getting back to the starting point, um, whatever comes in a second step, first of all, I believe that citizens have to accept it, and the government has to provide a matching frame where from or starting point from where mediation can develop in a positive way.
Like Professor, I am telling you that in India, the Indian government has presenting a new law by which commercial disputes should be first go to a mediation process before filing any litigation. It is a compulsory one for the commercial disputes uh, from the district courts to the High Court and the Supreme Court. Every commercial dispute must be go first to the mediation process, and then only commercial dispute can file commercial dispute parties can file a litigation. So the scenario in India is now has been to take a step forward in respect of mediation. I think it is a good one, but definitely your point in respect of councils who are representing the parties during litigation, their rights and their earnings has been hurted by this process. So there should be a question mark upon this. Definitely, definitely.
Yeah, just one question. Does this law also include social conflict, or is it only limited to commercial conflict? That it is mandatory pre-court process.
It is right now. It is only for a compulsion upon the only for a compulsion disputes only. But the Indian courts generally do this thing that once a litigation has been filed, then they first try to resolve any social dispute, even a family disputes, property disputes, for by virtue of mediation. There
Yeah.
is a specific sittings has been taken place when mediators are there in district and Supreme Court and High Court. They are providing services to resolve their disputes of the parties during the process of litigation even.
Yeah. Yeah. So this is a good starting point. Don't you agree?
Yes, yes, definitely. So, the other point which I have to mention here that uh, can you tell us, as right now that India has abducting this mediation process to resolve disputes, commercial disputes, family disputes, and all, and now there isn't any difference around the world and the process which will taken place in India in respect of the mediation.
Well, definitely yes. There are, when you compare country to country, you will note that there are just countless differences, conceptions, and also assumptions towards the topic of mediation, and that it truly varies from country to country. And this, I think, is actually due to the social and cultural background of the habitants, as well as to the thematic understanding of the process. And of course, as we already discussed, it depends on the fact if it is a mandatory pre-court process or not. So the diversity of mediation on a global level might require maybe a separate interview, as it is truly complex. We have uh, an American model, a European one, and an Asian one, and not to forget about Africa. So mediation differs everywhere a bit, and and specifically, as I said, the people's understanding of what mediation is and may bring is very, very diverse and truly interesting, as we live in a global society. So we cannot just concentrate on our country in order to understand what is globally happening.
Definitely, Professor. And I just willing to another webinar on with you on this topic, specific with the difference between mediation process taking place in India and the other countries. We'll do this definitely. Uh, but on the continuing of this webinar, I must ask you one more question. Must a settlement agreement by writing to be enforceable? Are there any other formalities?
Okay, well, this is also a very interesting point, and that might also be directly connected to the country's setting of it towards the practice of mediation. The main difference may be identified once again between countries where mediation is a mandatory pre-court process and where it remains more likely a totally voluntary process. Basically, an attempt to solve a conflict only makes sense if there is a true intention to follow up on the scheduled agreement. So in order to also have a sustainable legal impact, it might definitely make sense to turn the agreement into an enforceable title. But as already said, it depends on the nature of conflict itself and on the country's legal system. As you said previously, in India, there might now be the difference between the commercial dispute setting and a social dispute setting.
The other question which I'd like to ask you, what are the challenges for a mediator during mediation process?
Well, basically, I think there are endless challenges a mediator needs to master during a mediation process. As you all may be aware of, each case has its own story, its own setting, background, and of course, a specific and unique environmental impact. And actually, it is one of the purposes of the WMO online training in mindful mediation and conflict management to train and to equip mediators in a way that they are able and flexible enough to handle these more likely non-predictable challenges.
Professor, can you tell us the importance of mediation in family disputes? Because in India, we have many disputes between families. There is a social structure kind of thing, and as you know, that the Indians are more of the persons are residing with the families, the bigger families. So now the time has been changed. The disputes has been coming arrive. So there is so many family disputes. So can you tell us the importance of mediation in family disputes?
Well, as initially stated, I understand mediation to be a social core skill that truly can be practiced by anybody, even by elders in a family setting, for example. So that means that mediation is or seems to be a perfect tool to support families in handling conflict in a short-term way. And I also think that it provides the participants with more understanding, transparency, mutual benefits that will generate a better and more effective platform for future conflict preventing dialogue. So, getting back to your question, I really think it is one of the best tools to handle dispute because it brings people to the table and makes them discuss right away what is wrong or what is right. And this is what we need nowadays in families, as we have the problem the cell phone is becoming more and more important. People are not used to discuss their conflicts, but to get into the isolation. And that's the worst thing that can happen to a family, from my perspective.
Professor, we are just trying to, as you know, that we are trying to uh, discuss here all respect of dispute. So now I come to this thing that is a mediation is a successful tool for a cross-border commercial disputes.
Well, cross-border commercial disputes can definitely be handled by mediation. But before entering a specific business case, it might be smart to verify the terms of conflict solution. For example, to understand and to get to know which jurisdiction may be valid in the case of a dispute, or how and where a mediation process may take place. So such a setting could definitely give also birth to the topic of online mediation.
So now that in this scenario during COVID-19, even when we are talking about the jurisdiction, So online mediation is a tool which we can be provided a more flexible, more impactful mediation process to all the parties who is in dispute, cross-border dispute between themselves. So, Professor, can you again can you tell me the importance of mediation in cross-border dispute and what are the history says in respect of the successfulness of cross-border mediation dispute?
Well, history gives actually credits to mediation over periods of thousands of years. There are references already of the use of communicating middlemen back in the ages of the Greek and Roman Empire. And mediation has always been a tool of diplomacy, while an easy and proper analysis can unveil its solid and ongoing use, not only in the setting of international conflicts, but also in the frame of much earlier aged intertribal conflicts.
Uh, Professor, now I come to a very complex and very important question for us, being an Indian citizen. Can a dispute like India and Pakistan relating to control of line of control and territories can resolve by mediation? What is your opinion in that?
Well, first of all, I truly pray that there will be a solution, a peaceful solution. Okay, so I pray for both states, as it is always better to live together in harmony. Because as we now witnessed, there are challenges like COVID-19 that nobody could predict, and we are now all facing it. So maybe this is also an opportunity to reflect on the fact that other disputes are just not that important than our health, first of all. But yes, mediation, I think, is like a peak platform of conflict. And each party has, of course, in your case, both of the countries have specific interests, fears, worries, strategies, and also goals. And to bring all these points into one agreement is quite a challenge, So first of all, parties need to truly wish to create a mutual agreement or to find a peaceful solution. That means that there should be a specific flexibility regarding fulfilling one's own goals. Mediation is a process of actually giving and receiving. And parties who do not wish to handle a conflict in such a sustainable way may possibly only use the process of mediation for lobbying purposes. What might have happened when we saw the international mediation process taking place in Vietnam and when the US came there and, nothing turned out. So it depends on both states, as we discussed, how far they want to go, and if a peaceful situation has a higher benefit to them than remaining in a conflict setting. It is sad to say, but a conflict also, more often than not, is calculated like a business case, especially when a conflict turns into a war. So there's a calculation and estimation. What is of a bigger benefit for us? Do we invest into war and have another benefit after solving the conflict by armed forces or not? So international mediation processes actually can be short-term solution facilitators, but more likely, and as we see it in the media all day long, international dialoguing is a very complex setting that depends on many visible and non-visible stakeholders. And due to its high complex construct, it often takes years. So to us, being civil persons, it might help us to understand that governments are at least well aware of diplomatic steps that they can take. So what make us wonder, or what might make us wonder, is why more often than not such conflicts remain untreated.
Hopefully, as you wish that the process of mediation, by the process of mediation, we can resolve dispute between these two big nations, and peace and harmony, which is a basic necessity for a human being. It should be fulfilled by virtue of mediation process. Uh, I really thank you, Professor. Yes, you are giving your views on three different type of mediation of family disputes. How can we use the mediation process during commercial this thing, and especially the cross-border issues between the two nations. So you have specifically giving an answer of our queries. I again request the participants, if they are willing to ask any question from the professor, you can write in the chat box here. I'll ask the question to professor directly, and he is available to answer on the questions. uh, we'll wait for 5 minutes. If you are willing to ask any question in respect of mediation and their process, you can feel free to ask questions.
So Vinit, maybe one more thing that I would like to say is one of the basic problems that I see when we talk about international conflicts and mediation is that people, when they think of mediation, they think of, as we also said, in the family setting. They wish to see results maybe within 2 weeks, or maybe 1 week, or 1 month. So as I tried to explain, and as you know, being directly involved in this conflict between, for example, India and Pakistan, such a peace process, so let us turn from mediation to peace process, takes years. So this is why I also mentioned previously, we should understand mediation, at least in such complex settings, as an open process, because circumstances also change. Maybe one country is ready to agree on the point, then something like COVID-19 happens and everything, the complete setting is changed. We have to keep it open because life itself is a changing process, and what is maybe correct to us personally today might be proven wrong tomorrow.
Professor, we have one question from our participants. She is asking for Surbi Ghosh. Uh, she is in Department of Faculty of Law from University. She is asking a question: is any international convention regarding mediation is there?
Well, maybe you were aware of the Singapore Mediation Convention that took place. So this is, to me, it is a very difficult point, not to talk about, but to put it into practice, because as we know, mediation differs from country to country. All legal, or not all, but mainly legal backgrounds and settings are diverse. So this is like, for example, when you come to, as a lawyer, to the point of international law, the first thing that you learn actually is that something like international law does not really exist, but there are country-related jurisdictions with their law construct. So I think we can differ between two aspects. The use of mediation, like in India, in a commercial and in a social structure. Okay, being connected to the national law. But on the other hand, we can talk about international communication, exchange, mediation between states, right? Because at this point, a legal setting is not really required because it is a process of consensus making, and it's just like when you use, for example, as a social worker, mediation tools, and a legal concept is not required. It's just about the result that you get. I hope this makes sense to you.
Yes, yes, definitely. We have many questions here. One more question. Uh, One of our participants from Bangladesh, he's asking, he's a law student, and he's asking, is there any set of rules and procedure for international conflict by any convention and this kind of thing?
Well, I think this question goes along with what I recently said. Um, International conflict is, let us say, beyond the national law construct. So more often than not, international mediation is realized by diplomats themselves. Maybe one of another trading organization or someone being the middleman, while both states might be part of the trade organization or something like that. So, but once again, in these cases, it's about the result. It's about the agreement that parties create, and then, as we talked about, the enforceable titles and so on. And then the more likely oral agreement might be put into words, and this best by lawyers as they are the skilled writers and analyzers.
Uh, Professor, there is any one more question. The function of rule for mediation. I think you have already been in the starting of our conversation. You have already been told about the function of mediation. I think if you can add something in this, there is a question of function of rule of mediation. If you are willing to add something and you are giving an answer of this question,
I did not get this point now. Sorry.
he's just asking a functioning of rule of mediation, how a mediation process has been taken place.
Okay. So in case this deals with the point that I mentioned, where um, the contract itself should have a conflict resolution clause, right? So it is just getting into or doing business, getting into a commercial situation is not about making friends. Well, hopefully yes, but it's just a written agreement, and in this agreement, by signing the contract, both parties just have to agree best on maybe one specific mediator that both know and do rely on the skills, or they appoint an association, a national one, that would determine the confirmation which country this organization should be based in. And then if this organization has a pool of mediators, then they might agree on selecting a mediator out of this pool. But this, once again, depends on the parties who are going to sign the contract.
Basically, the point you have in the starting of our conversation, you have said that mediation is a process on a different point of time. It will be a different when a commercial dispute has been taken place, when a dispute between the two nations in respect of any territory and this kind of taken place, or family dispute. There is different rule and regulation for every dispute. Sometime it will be a willingness, sometime be a written contract, by virtue of written contract. So there is a different scenario when the mediation will be taken place. Professor, there is so many questions has been coming. So I just come to you with the two more questions.
Sure.
Very interesting question from one of our participants. Is it true that who come up with the mediation will win for the both the parties?
Well, of course, we wish that there will be a win-win situation. And at the end, it depends on the participants how long they want, for example, to join a mediation process. And at the end, if they agree on the mediation agreement, in case the process comes to the point that there is an agreement. I said that I would like to call mediation an open process because sometimes there is not even it is not even necessary to create an agreement. People or participants or parties sit at a table or meet online or however this will be or is practiced nowadays and exchange. They get into dialogue. They hear the other party's perspectives, and maybe uncertain points become clear. So this is why I said I would never sell the idea of a win-win or of a situation or of an agreement at all, because sometimes the conflict just disappears by listening to the other party's perspective. But of course, it is our belief that when the agreement is of a positive nature to both parties, it is the best source that both parties in the future, after the mediation process, will follow up on what was agreed on.
Basically, if a party has agreed to come to a mediation, they must be come with an open mind to resolve the dispute first. That will be an impactful one. One more question, Professor. One of our participants, Gurmeet Singh, is and Mr. Goel asking a difference between mediation and arbitration process.
Well, I like to say that mediation and arbitration, or arbitration and mediation, are like brothers and sisters. But of course, there are specific differences. As I said, that in the mediation process, it is a team process. No, both parties, even the mediator, gives and receives. Give attention, receive attention, places answer questions, receives answers. Both gain hopefully understanding. So it's an open team process. And as I said, none of these participants has a proper control only over the process, only about or only on the proportionate supportive fragment that they are responsible for. So this might be the main difference to arbitration, that is a team process. Even though in arbitration there is an exchange and the purpose to communicate one's position, but in the end, the decision making, I believe, is less a teamwork than it is in mediation.
Professor, there is one more question I would like. This is the last one. Other question, we have so many questions here, but I will mail to you all the question and we send it to the participant with the answer. One more question I would like to ask. One of our participant is asking that during mediation process, a party, a commercial dispute, when the commercial dispute has taken place, a party who is giving a money to someone, is it true that he is in upper hand during the mediation process? and it can be resolved by virtue of the mediation process.
Sorry, the setting there is that there are two parties in a mediation process, and one is leaning money to the other one.
Yes, yes. If someone give money to the other party, the party who is giving money to the other one
Okay.
is he's having a upper hand in during mediation process.
So you mean they give one party gives money to the other one in order to find and promote an agreement, or maybe to okay. Well, I think this is not actually part of a mediation, but or as we what we understand as mediation. But in the end, it is also part of conflict management, because offering money is one thing, accepting the money is something else. So what was offered by the party who provides the money would be like an agreement from the other side by accepting the money. And if this is some sort of reconciliation, for example, that is totally acceptable from my perspective.
Definitely, the mediation process is not especially in a commercial dispute, and the dispute between nations is not the thing which is do by the any person. It should be like you has been said that it is a process and it is to be done by a trained mediator. There should be a training for the mediators to resolve this kind of dispute. The trained mediator should be there. So
I think this is actually something that often happens when in very simple commercial cases, when items are ordered online. No, they arrive damaged, or they arrive in a good state, but just work maybe 2 days. So there is such a situation, so is the money getting back, or do they have to send it back? So who's going to cover the sending costs and so on? So this is maybe an example that makes it clear that transferring money from one side to the other side is not mandatorily something bad.
Professor, I really thank to you. Now, this is a closing remark on my behalf. Thank you, Professor. This is an exciting session, and thank you all the participants for posting your queries. You can see our recorded version of this webinar on our social media account, platform like YouTube, Facebook, and LinkedIn. Just go and subscribe our page. It is for the past recording, and future programs, future schedule. You can subscribe our Facebook page. Thank you all, Professor. Thank you very much, and hopefully we'll come to you again with a specific discussion upon international mediation and mediation taking place in India. The process.
Yeah, sure. It would be my pleasure. And as well, we have a limited time frame, so I'm also grateful for all the questions that were provided. And I would still like to say something, if I may, to all the participants. And it is basically that I truly wish that the government in India and in all the other countries that where we have our audience based in takes all necessary steps to create a fruitful future for mediation, but also for peace building and, very important, respectful non-armed dialogue. And I further hope that it will generally be understood that living in a frame of legal, social, and emotional peace has a very positive impact on the development of the society and also even on the economy. So what counts is not making money by conflict or war, but we all should concentrate on building a peaceful future by respectful coexistence. And this is, Vinette, why I'm also very grateful that you offer this platform and this stream, because it connects so many people from so many countries, makes us all learn a bit more, understand each other, because I'm also learning from the questions and see the need of information. And we're getting closer and closer as a global community, standing in for peace. And I think this is nowadays the best thing that can be done.
Thank you, Professor, and you're very kind to give an answer of all the question of the participant, and hopefully our participant will be satisfied with your answer. We'll send it to you some of the questions which is sent by our participant, and hopefully you will, when you find a time, as you are a very busy person, so when you find some time, I request you to just treat and give the answer of the question, and hopefully we'll come to you again with some other webinar. Thank you.
I hope so too. Thank you so much. Take care, everybody. Yeah. Bye bye.